Next, I want to cover the steps that are required to obtain a general distinguishing number, that's your GDN or your dealer's license, and we are going to cover the entire process, including submitting your application, criminal history, your business building, your display area, your business sign and business hours, the state's dealer surety bond requirements. Then we're going to cover registering your name with the Secretary of State's office, registering with OCCC if financing, records, I-9 employment form, your employer identification number, sometimes we call that an EIN, dealer educational course, and then I'm going to show you how to pay your license fees with credit card or e-check. Submitting your dealer application at e-licensing. You must submit your dealer application through the Texas Department of Motor Vehicles e-licensing website. Your application must be submitted online. The Texas Department of Motor Vehicles no longer accepts dealer license applications by mail. You may submit your dealer license application at the Texas Department of Motor Vehicles website, which you'll see right here, and you're going to be able to pay your license fees with a credit card or e-check. The application process is quite extensive and must be completed correctly and in its entirety. Mistakes on your dealer application can cause significant delays in your licensing process. If you need assistance during the e-licensing process, you can call 888-368-4689, which is the Texas Department of Motor Vehicles Consumer Relations Division, and we will submit a dealer license application online later in your dealer training course. Fingerprinting and criminal history review. The Texas Department of Motor Vehicles has adopted new rules requiring certain new dealer license applicants and existing dealer license holders to be fingerprinted. All dealer applicants will be subject to the new fingerprint requirement. As part of the Texas Department of Motor Vehicles' efforts to prevent and deter fraud, the board adopted a rule requiring applicants for and holders of all types of dealer general distinguishing numbers to be fingerprinted. All persons acting in a representative capacity for a dealer license applicant or a holder of a dealer license must also be fingerprinted. Even if you have been previously fingerprinted for another license or by another government agency, you are still required to submit to the Texas Department of Motor Vehicles a set of new fingerprints. You do not have to get fingerprints every time you renew your dealer license. The fingerprint requirement is a one-time requirement if an active license is maintained. However, if you fail to submit a timely renewal or allow your license to be closed, you will be required to submit new fingerprints if you apply for a subsequent license in the future. Fingerprinting services are provided through a fingerprint provider called Identigo, and you will pay your fingerprint fee directly to the fingerprint provider. Results of the fingerprinting will be sent directly to the Texas Department of Motor Vehicles from both the Texas Department of Public Safety Crime Records Division and the Federal Bureau of Investigation. If you cannot schedule an appointment at a LiveScan Identigo location, or if you're located outside the state of Texas, you must be fingerprinted in ink on a standard FD-258 fingerprint card at a local law enforcement agency or other agency that's certified for fingerprinting. Additional instructions regarding this method of your submission will be included in your instructional email from the Motor Vehicle Division. It is very important that you follow the following fingerprint instructions correctly. The following dealer applicants and license holders are required to be fingerprinted: franchise motor vehicle dealers, independent motor vehicle dealers, wholesale motor vehicle dealers, motorcycle dealers, trailer or semi-trailer dealers, and independent mobility motor vehicle dealers. The following persons must be fingerprinted: owners, presidents, managing partners, persons acting in a representative capacity for an applicant or a holder of a license, including the applicant or the officers, directors, members, managers, trustees, partners, principals, or managers of business affairs. Once your application is submitted to the Motor Vehicle Division, the Motor Vehicle Division will review it to determine who on your application needs to be fingerprinted. The Motor Vehicle Division will then send an email to the application contact notifying them who on the application is required to be fingerprinted. Fingerprinting services will be available via the approved vendor Identigo. Please do not go to the vendor to get fingerprints taken until after you receive confirmation from the MVD that the fingerprints are required. I want to repeat that very important statement. Do not report to your fingerprint location until after you receive confirmation from the Motor Vehicle Division that your fingerprints are required. Fingerprints are now required for most dealer license applicants. Before you receive your dealer's license from the Texas Department of Motor Vehicles, the Texas Department of Motor Vehicles must review your criminal history and the criminal history of all owners and managers listed on the license. All owners and managers must disclose all prior offenses, both convictions and those that resulted in deferred adjudication in any jurisdiction. All convictions and deferred adjudications must be disclosed regardless of whether the sentence was completed and is considered dismissed or expunged. I also want you to be aware that once a license has been issued, any new offenses that result in conviction or deferred adjudication by any owner or manager in any jurisdiction must be reported immediately through e-licensing by selecting the Amend a License option. Criminal history will be reviewed on all new license applications, renewal license applications, and amendment applications that reflect any change in ownership or management. The existence of a criminal history does not automatically disqualify a person from gaining a dealer's license. The Texas Department of Motor Vehicles will review criminal history on a case-by-case basis. When you complete the information when applying for your license through the e-licensing system, you must answer all questions correctly, not only for yourself, but for each owner and manager listed on the application. If you make false statements during your application process, you may have your license denied, canceled, revoked, or suspended. You may also face criminal prosecution. Many of the rules governing criminal history are listed in the Criminal Offense Guidelines in Chapter 43 of the Texas Administrative Code, Rule 211.3. And in just a little while, I will show you how to easily look up the rules in the Texas Administrative Code. If you have a criminal history, court records must be submitted with your dealer application. And those records can usually be obtained by contacting the district court or the county in which the offense occurred. Business building. You must have a place of business to be used for the purpose of selling motor vehicles. It must be located in a building with connecting exterior walls on each side. The building must meet all local zoning requirements. The building must either be owned or, if the building is leased, the lease must be for at least 2 years. You must have an office in the building for the operation of your dealership. The office cannot be located within an apartment house, hotel, motel, or rooming house. If the office is located at a private residence, it must be completely separate from the actual residence and must meet the zoning requirements from that city or county. Before you rent or purchase a building to operate your dealership, you must contact your local planning and zoning office at your city hall or your county courthouse to ensure that you can operate a dealership at that location. A certificate of occupancy, or we sometimes call that a COO, is required if a certificate of occupancy is required by your city or county. So the certificate of occupancy must be in the name of the dealer's business and must state the use. For example, it must clearly disclose that you'll be selling motor vehicles. Texas Department of Motor Vehicles enforcement officers may request documentation to ensure all zoning requirements have been met. The office should be, at minimum, have a desk, 2 chairs, internet access, and a working telephone listed in your dealership name. I want to repeat that. Your office must include, at minimum, a desk, 2 chairs, internet access, and a working telephone listed in your dealership name. The dealer phone number may never be shared with another dealer. You must always have your own phone number. And by the way, the internet access that you're required to have may be wireless internet access. If a dealer shares their location with another business, the dealer must have their own office area. The state allows up to 4 retail dealers in one building and up to 8 wholesale dealers to operate out of a building. But remember, wholesale dealers and retail dealers can never operate out of the same building. Display area. Your display area must be sufficient size to display at least 5 vehicles of the type for which the GDN is issued. I want to repeat that. Your display area must be of sufficient size to display at least 5 vehicles of the type for which your GDN is issued. Those spaces must be reserved exclusively for the retail dealer's inventory and may not be shared or intermingled with another business or a public parking area or a driveway to the office or another dealer's display area. So you can't intermingle inventory whatsoever with another licensed dealer. The display area may be located outside of the building or inside the building. This retail sales area must be kept separate from any wholesale vehicles being held for resale. Also, retail and salvage inventory needs to be kept separate at all times. The display lot cannot be a driveway and must be some type of hard surface such as concrete or gravel. Some local zoning ordinances may require a dealer display lot to be paved. The lot must meet all local zoning requirements. The display lot must be separated from any other businesses or repair shop, a driveway to the office, or another dealership's display area as stated earlier. If a retail dealer shares a display area or parking area with another business, including another dealer, the dealer inventory must be separated from the other business's display lot or parking area by a material object or some type of barrier which cannot be readily moved. Such separation shall be properly maintained during your entire period of licensure, which a used motor vehicles dealer's license is being held. If a dealer is going to operate at night, the display area must be illuminated. Dealers can have a display area that is not part of the lot. The display area must be located at the retail dealer's business address or contiguous with the retail dealer's address as well. A non-contiguous storage lot is permissible only if there's no public access and no sales activity occurs at the storage lot. A sign stating the retail dealer's name, telephone number, and the fact the property is a storage lot is permissible. If your customer is interested in a vehicle that you have on a storage lot, then you or a salesperson would need to bring the vehicle from the storage lot to the retail sales lot to show the vehicle. You may never have any type of sales activity on a storage lot. Once you become a licensed dealer, you may only have retail sales activity at your licensed location. And I want to talk about this for just a moment. Let's say your lot is in downtown Austin and someone just outside the city finds your vehicle for sale on the internet. They might state that they can't make it downtown and ask you to bring that vehicle to a parking lot near their home. Remember, we can never, ever show the vehicle at a non-licensed location. Conducting any type of retail sales activity away from your licensed location is a violation of the law. So you will have to explain to some of your customers that the state does not allow you to show your vehicles at a location away from the dealership. The retail sales activity may only take place at your licensed location. Wholesale vehicle dealers are exempt from the display area requirement. Your business sign. You will need a permanent business sign that is visible from the public roadway. The dealership name on the sign must be at least 6 inches high or larger and must match either the DBA certificate filed with the county for sole proprietors and general partnerships, or the business name DBA registered with the Texas Secretary of State if you're opening your business as a corporation, LLC, or an LP. And by the way, we will cover business registrations in just a few moments. The sign must be mounted at the address listed on the dealer application. Your sign must match the exact name on your dealership as it is listed on your dealer's license application. The sign is not required to have business entity information such as Inc. or LLC or LP, etc. The sign must be permanent in nature and be clearly visible to the public. A banner is not an acceptable business sign, nor are magnet boards or handmade cardboard signs. A dealer may use a temporary sign as long as you can produce a sign order that shows this sign has been paid for and ordered. You know, most printing companies can produce a permanent business sign at a very minimal cost. Wholesale dealers must follow the same requirements, that is permanently mounting an outside sign with 6-inch letters, but they may also mount a sign on the office door with 2-inch letters if the landlord does not allow outside signage. So be sure the letters in the dealership name meet the minimum height requirements under Texas state law. Business hours. A retail dealer must be open at least 4 days a week for at least 4 consecutive hours per day. A wholesale dealer must be open at least 2 days per week for at least 2 consecutive hours a day. I want to repeat that very important statement. A retail dealer must be open at least 4 days a week for at least 4 consecutive hours per day. A wholesale dealer must be open at least 2 days per week for at least 2 consecutive hours per day. Business hours must be prominently displayed near the entrance to the building. You may post your business hours on the front of the building, on a window, or even on your business sign. Each dealer must post their own hours if an office is shared, and that dealer's hours must be posted even if a location is shared with any other type of business. The dealership must be open and staffed during the posted hours of operation. The dealer must be staffed by a bona fide owner or employee. If you're not able to staff the dealership during the posted hours due to an emergency or some special circumstances, you must post a sign that states the date and time that you will return. If the dealer ever changes the hours of operation, the Department of Motor Vehicles does not have to be notified. Any customer must be able to view your inventory without an appointment. Regardless of the retail dealer's business hours, the retail dealer's telephone must be answered from 8 a.m. to 5 p.m. weekdays by a bona fide employee or answering service or answering machine. Texas Blue Law prohibits a dealer from selling vehicles on consecutive Saturdays and Sundays. A dealer may choose to be open on a Saturday or Sunday, but not a consecutive Saturday and Sunday. For example, a dealer could be open on Saturday this week and Sunday the following week, or vice versa, but never on a Saturday and Sunday on the same weekend. Travel trailer and trailer semi-trailer dealers may operate 7 days a week. If a person holds a motor vehicle license and a trailer license, they may open on Saturdays and Sundays consecutively, but cannot sell motor vehicles on a consecutive Saturday and Sunday. I want to repeat that. If a person holds a motor vehicle license and a trailer license, they may open on Saturdays and Sundays, but cannot sell motor vehicles on a consecutive Saturday and Sunday. Motor vehicles can only be sold on a Saturday or Sunday that are not consecutive, never on a Saturday and Sunday on the same weekend. I hope you caught all that. Dealer surety bond. You must obtain a $50,000 dealer surety bond in order to obtain a Texas used motor vehicle dealer's license. I want to repeat that. You must obtain a $50,000 dealer surety bond in order to obtain a Texas used motor vehicle dealer's license. The surety bond is used for replenishing funds used to compensate retail purchasers of motor vehicles. The name and address on the dealer surety bond must match exactly the name on the dealer application filed with the Texas Department of Motor Vehicles. The bond must be issued in the legal first and last name of a sole proprietor or a general partnership if the business is a sole proprietor or a general partnership. For all other business entities that file with the Texas Secretary of State's office, the name must match the exact full name of the registered business name. The bond must be issued for 2 years and must start on the first day of the month and end on the last day of the month corresponding to the license term. For example, September 1st, 2021 to August 31st of 2023. You must maintain your bond during your entire licensure period. The bond must be signed by both the owner and the bond company representative. I want to repeat that. The bond must be signed by both the owner and the bond company representative. This is one of the most common mistakes and can cause delay in your dealer license approval. The bond must include a proper power of attorney from the bonding company. A bond writer may be required if bond information is incorrect or needs to be revised. Franchisees, travel trailer dealers, and trailer semi-trailer dealers are exempt from the dealer surety bond requirement. And as you can see there at the bottom of the screen, state law does now require that you post your bond notice and claim instructions right next to your dealer's license. I want to repeat that. The law now requires that a dealer post your bond notice and claim instructions right next to your dealer's license. So you'll be able to download this official form from the Texas Department of Motor Vehicles website. Dealer bond notice and claim instructions are required by law to be posted right next to your dealer's license. The bond pricing is based on your credit score. A dealer surety bond can be obtained from an insurance agent or a bonding company. Registering your business with the Texas Secretary of State. You must register your business name with the Texas Secretary of State and include copies of each registration with your dealer application. Most business entities will be filing this paperwork with the Texas Secretary of State because the Texas Secretary of State wants to have a record of every business that is operating in the state. Sole proprietors and general partnerships are excluded. However, sole proprietors and general partnerships must file an assumed name certificate in any county they operate if they're using a name other than their proper name. Registering your business with the Secretary of State is covered in great detail later on in your dealer training course. For additional information on registering your business, you can contact the Texas Secretary of State's Business and Commercial section via email, and that's going to be at corpinfo@sos.texas.gov, or you can call them directly at 512-463-5555. Licensing with the Office of Consumer Credit Commissioner if financing. Before you offer third-party financing or buy here, pay here financing, every dealer in Texas must obtain a license with the Texas Office of Consumer Credit Commissioner. And you can obtain the license at occc.texas.gov, or you can call them directly at 512-936-7600 for further information. We're going to cover the licensing process with the Office of Consumer Credit Commissioner extensively later on in your course. Records. You must maintain records on all vehicles purchased, leased, and sold for a minimum of 48 months. That's 4 years. The current and previous 13 months of records must be kept at the dealer's license location and be ready to be produced for inspection by a Texas Department of Motor Vehicles representative. The remaining 35 months records can be stored at a location other than the license location. Records may be stored either via paper or electronically for a period of at least 4 years. That's 48 months. Federal law requires some records to be kept for at least 5 years. We're going to review an entire section on exactly what records to keep later on in your dealer training course. I-9 Employment Eligibility Verification. The Employment Eligibility Verification Form I-9 is a U.S. Citizenship Immigration Services form, and it's used by an employer to verify an employee's identity and to establish that the worker is in fact eligible to accept employment in the United States. You can find that form at www.uscis.gov. Federal law requires you complete this form for every person whose name appears on the dealer license and all future employees. You do not need to submit this form with your application, but you must store a copy of the form at your dealership location. Employer Identification Number, or EIN. Before submitting your dealer application, you must obtain an Employer Identification Number, which is also known sometimes as a tax ID or EIN. The number is used to identify the new business you are starting and will be needed for tax purposes. Obtaining this number is a very quick and easy step that will only take a few minutes, and you can easily apply at the IRS website. That's www.irs.gov, and have your new employer identification number in a matter of moments. After you've been assigned your EIN, be sure to include it on your dealer license submission. And once again, we're going to cover this process extensively later on in your dealer course. Speaking of your dealer educational course, a 6-hour web-based pre-licensing training requirement applies only to dealers with an independent motor vehicle GDM. These dealers are licensed to buy, sell, or exchange used cars, trucks, motorhomes, neighborhood vehicles, recreational off-road vehicles, those are ROVs, all-terrain vehicles, which are ATVs, and utility vehicles, which we refer to as UTVs. Most applicants for new licenses and renewal applicants licensed less than 10 years on September 1st of 2019 will be required to complete the one-time training. An owner or manager listed on the application must be the person to complete the course. If a person who completes the course leaves the dealership or the business, then another owner or manager for the business must take the course prior to the next renewal. If a dealer has been licensed for more than 10 years as of September 1st of 2019, that dealer does not have to take the course. If a dealer has been licensed for 10 years or less as of September 1st of 2019, then only the renewal course needs to be taken. If a dealer has already taken the new applicant course or the renewal course and applies for a new license, then the dealer can just upload a copy of the course completion certificate rather than taking this course again. You're going to receive your official certificate of completion at the end of this course. You will need to submit this with your license application when you submit it through e-licensing, and I'll show you exactly how to do that here in just a little while. Licensure fees. The fees for your dealer license are listed here. This example shows fees that include one optional metal dealer plate. You will be able to pay for your license securely with a credit card or e-check. Most, but not all GDN dealers may receive up to 2 dealer plates. And there you can see the general distinguishing number fee is $700. Metal dealer plates fees are $90. And we will cover this extensively here in just a little while. Texas law requires that all dealer licenses are displayed prominently at the location, and a new law also requires that you display your bond information right next to your Texas dealer's license as well. All Texas dealer licenses are valid for 2 years from the date of issuance. If your license requires a dealer surety bond, your license would expire on the same day as the dealer surety bond expiration. You may not start the operation of your dealership until you receive your dealer's license. That's your GDN. All dealer license applications, renewals, and amendments must be submitted online through the e-licensing system. It is your responsibility to renew your dealer license in a timely manner. You should submit your renewal at least 45 days before your dealer's license expires. Dealers have up to 90 days before and after the license expiration date to renew. Late penalty fees are charged when the renewal application is submitted more than 30 days after the license expiration date. A $200 penalty must be paid if the application is submitted 31 to 60 days past the expiration date. The penalty increases to $400 if an application is submitted 61 to 90 days past the expiration date. A dealer may operate multiple locations within the same city. Dealers must submit an amendment application in e-licensing if relocating within the same city or adding or removing an additional location. Any additional locations in the same city are considered supplemental locations and do not require a separate dealer's license. Dealer licenses are city-specific, and a separate dealer license is required for every city a dealer is operating in. If a dealer relocates to a new city, then a new license, including a new dealer surety bond, is required. Remember, independent motor vehicle dealers may also operate as a salvage dealer without obtaining a separate salvage license. However, a sales and use tax permit would be required if operating as a salvage dealer, along with a National Motor Vehicle Title Information System number. We'll talk about that here in just a little bit. All GDN and salvage inventory must remain separated. Let's go over your dealership premises restrictions. Retail dealers may not operate in the same building as wholesale dealers. Retail dealers may not operate in the same building as a vehicle lessor licensee. Retail dealers may not operate in the same building as a lease facilitator licensee. Salvage vehicles must be kept separate from retail vehicles. And remember, you must notify the Texas Department of Motor Vehicles within 10 days of opening, closing, or relocating any dealership in the state.